It was a relief for the accused in the Nulani procurement fraud case when the High Court handed down a damning judgment that berated the state's lack of evidence. Former Free State heads of the Department of Agriculture and Rural Development, Peter Tabete, and Makatso Morosi, former Chief Financial Officer of the Department, Sipati Dlamini, Gupta associate businessman Iqbal Sharma, his brother-in-law and a representative of Nulani Investments, Dinesh Patel, and Island Site Director Ronika Raghavan were found not guilty and set free.
Most of the witnesses for the state, when confronted with the whereabouts of the originals, simply pled ignorance, and those who ventured to proffer an opinion fell back on the Glen relocation. The rationale for the originality rule is palpable: to avoid error and falsification. It is for that reason that the mere say-so of the officials that the documents are lost and/or that despite a diligent search, the originals could not be located will not suffice.
The NPA suffered a blow when the accused in the first state capture-related case were discharged. However, the NPA's Investigating Directorate persisted that the outcome had no bearing on its ability to prosecute other state capture-related cases. The Independent Directorate took the legal tussle to the Supreme Court of Appeal, describing Nulani as wholesale looting contract that the Free State government signed with Gupta-associated Nulani Investments to conduct the Muhuma Mobung feasibility study. It argued that Judge Gusha had prejudged the matter because she didn't understand the basic legal principles of the documents the state presented to the court.
The Nulani statement shows the half of 24.9 million, 12.4 million, something hits into the Nulani account on the 8th of November. But that time they've done no work, nothing. No commercial rationale, pure theft in terms of the regulatory framework. That's common cause. It was common cause. If you had an experienced judge, and I would submit a matter like this, you give it to your most experienced criminal judge. Experienced judge would have said, but what are we fighting about? I'm going to sit here why you guys did this, babe.
And the judgment was a turning point, aiding the prosecution after facing backlash for failing to prosecute the state capture-related cases. It ordered a retrial of the accused before a different judge, which vindicated the NPA's firm view that Judge Gusha erred in her strong criticism of the prosecution.
We remain resolute in our stance of effectively prosecuting and holding accountable those responsible for state capture-related corruption. Beyond this important case, IDEC has made significant progress in its effort to ensure accountability for serious and complex corruption and related crimes stemming from the state capture era. It has enrolled so far 50 cases, declared 133 investigations, and partnered with the NPA's Asset Forfeiture Unit to obtain freezing and preservation orders amounting to over 14.2 billion, with 8.2 billion in confiscation orders deposited to the criminal asset recovery account.
A legal analyst says new evidence and witnesses may be brought to the new trial.
Yes, it means that the case is going to start with all the documents that was presented to the state and to the legal representative when this case started. And they're going to use the very same documents that they had, and they still allowed with an agreement between the state and the NPA, if they want to bring the new documents which has a new evidence on it, they are allowed per agreement between two parties.
It is not clear yet when the matter will sit before the High Court for a retrial. The SCA found that the High Court made numerous errors of law that resulted in the acquittal. It labeled the initial trial as a failure of justice, which regrettably erodes public confidence in the criminal judgment. The SCA ordered that the accused be retried for the same offences as if they had not previously been tried and acquitted. Makgala Masiteng, SABC News, Bloemfontein.